Hello and welcome back to our YouTube channel. Well, it is lecture number 24 today of Indian Polity and the date is 9th July 2025. So, in today's discussion, we are going to discuss a few more facts related to Union territories, and after that, we will discuss the question which could be asked in the mains exam, whether the Union territories do stand with respect to the present democracy. We'll discuss that. After that, we'll go to the center-state relations. So these would be the core concept of our today's discussion. But before we'll start our discussion here, I would like to give the brief introduction about the initiative, which we started from 2nd June, and the name of the initiative is Target IAS 2026. So that if you are new to our channel, you will get more connected with us. Basically, from 2nd June, every day we try to upload 2 videos on our YouTube channel. One in the morning session, where we take care of your current affairs, and second in the evening session, where we discuss your static syllabus, which is this video. And in the evening session, we started with Indian polity, and currently it is the 24th lecture. So we are about to complete the Indian polity. So, and we had promised you by the month of January 2026, we are going to complete your full syllabus, whether it would be related to your prelims or related to your mains. But the exception is that we are not going to conduct the classes for the optional subjects. And also one more thing, as we are delivering these lectures, at the same time we are preparing your notes, which are very much, different from your conventional books, because after every discussion of every topic, we had discussed various questions with respect to those topics. With respect to your prelims preparation, we had brought the prelims model question there, as well as the mains model question if anywhere it was necessary, so that it will give you the proper idea while reading the notes, while reading those concepts, how it can be relevant for your preparation. But here is a condition: if you want to get the service of these notes, you would have to mail us on our mail ID, which is given in the bio, and you would have to pay only 200 rupees for the notes, only 200 rupees. And it is very much optional. If you want to do this, it is up to you, and rest everything is free. This is the coaching which we are doing, which we are delivering here for you guys, totally free. It is the same coaching for which you go to institutes and pay in lakhs. So it is up to you. If you want to be the part of it, just subscribe the channel, share it with your friends, so that they may also get connected with us, and do also write in the comments what else should we bring for you guys. Now, without any delay, let's start our discussion and start from where we left yesterday. We started the union territories. We discussed that how union territories are different from the states. The federal structure, which our constitution guarantees us, how UTs are different. We discussed that. And even in UTs, all UTs are not same. There is a division. There is definitely the division. Suppose we have 5 UTs which even don't have the legislative assembly, who are directly controlled by the center. And then we have 3 UTs for whom we have the legislative assemblies, but still with the conditions. For example, for Puducherry, we have the legislative assembly. For Delhi, we have Article 239 AA. So we have different conditions, and for J&K, what applies to Puducherry, same applies to J&K. And still, we understood yesterday, even though we have the legislative assemblies in these UTs, but still, if the center wants to make any law, they can make it, and the state can do, and the UT can do nothing about it. Eventually they are at the mercy of the center. We discussed all that. But one question I raised yesterday, if you remember that what was the need of the UT? What was the need of union territory? We also discussed the concept of UT with respect to Delhi. We discussed it in a very detailed way. We discussed how before 1955 it was a state, then after 1955 it got, it became the UT till 1992-93. It did not have the legislative assembly. Then after that, it had the legislative assembly. Then from 2013, how the NCT of Delhi, it was the hot topic every time with respect to the Supreme Court. Whereas decisions made by Supreme Court, we discussed everything in detail. Now today's question is, what was really the need of the UT? What was the major reason for that? We discussed a few which are proclaimed by many books, that The major reason was administrative and political and for political purposes and for the administrative purposes. Then we saw the distinctive culture, that was one of the reason highlighted. Security, that was also one of the reason highlighted. Even though they are relevant, but still there are various contradictions to those reasons. There could be various contradictions, but here today we will discuss it in a very systematic way. We will discuss what does the constitution say about it, what does when the state reorganization commissions were created, when their reports were laid down, what were their concerns with respect to UTs, what did they say about that. So let's try to understand that. Before 1955 we had four types of states which we had discussed. We have part A, the bigger states. We have part B, the princely states. We have part C, a kind of UT which we have today. They were under the chief commissioner, and then we have part D, in which we have Andaman and Nicobar Islands. So these are the four states which we had before 1955. Then there was discussion, should language be the reason for the formation of the state, should language be the reason for that, and various discussions were there. And finally the state reorganization commissions were created. Various commissions were created. For example, JVP commission, Sardar Patel commission, various commissions were created with this regard, whether there should be the whether it should be whether the language should be included, it should be the could be the reason for the creation of the state. So in this regard, the state reorganization commission's report was laid down, and it has highlighted that finally in 1955 state reorganization commission, it highlighted that the language can be the reason for the state. And on this basis, there was the need, the states were created. On different reasons the states were created. And at the same time, it was highlighted that there, in the three areas we should create union territories. At the same time, it was highlighted in the state reorganization commission that in the three areas we should create union territories. What were those three areas? It was Delhi, it was Manipur, and it was Andaman and Nicobar Islands. So what was the reason for the Delhi? It was because it is a capital. Definitely it is the reason. We need to have the administrative control over it. There are embassies of the different countries are there. The central business is happening there. The federal business is happening there. So capital, it should be under the control of the center, which we discussed yesterday too. For the Manipur, what was the reason highlighted? There were insurgencies in the Manipur, and for that the security reason was the criteria that we should make it as the union territory. Then what about Andaman and Nicobar Islands? For this, the reason, which it is what the report is saying. Yet we are discussing the report, then the act came in, and through the act we had 6 UTs. So what does the Andaman and Nicobar, what does the report say here? That the report says other compelling reasons. For the Andaman and Nicobar, the report says other compelling reasons. This other compelling reasons, it is not well defined. This is very vague term, and it can lead to different interpretations. Other compelling reasons, it can lead to different interpretations. So these were the reasons which were highlighted. And for your understanding, in 1956 till 1955, Delhi was also a state, but in 1956 Delhi became the first state. Delhi became the first state who was downgraded to UT. We can say in our tongue that it was downgraded to the UT. It was downgraded. Delhi became the first state in 1956 which was downgraded to UT, and finally in 2019, the second state which was downgraded to UT is Jammu and Kashmir. So these were the reasons highlighted in the report, that for what purposes we should create the UTs, and 3 UTs should be there: Delhi, Manipur, and Andaman and Nicobar. For Andaman and Nicobar, the reason was other compelling reasons. But when this State Reorganization Act was brought in 1956, it highlighted few other issues with respect to that. So let's see what does the State Reorganization Act of 1956 say about it. State Reorganization Act of 1956. So what did the report said? Report said that we should have the UTs, we should have states created on the basis of language. At the same time, it said that we should have three UTs: Delhi. The second one was Manipur, and the third one was Andaman and Nicobar. For the Delhi, it would be the administrative reasons; for the Manipur, security reasons; and for the Andaman and Nicobar, other compelling reasons, which is very vague in its nature, which can lead to the different interpretations. Then finally, in 1956, the State Reorganization Act came in, and under this act, 6 UTs were created. How many UTs? 6 UTs were created. And what were the reasons highlighted for the creation of these 6 UTs? Reasons which you need to understand. There were 2 reasons which were highlighted. First reason was low resource base. First reason was low resource base. The second one was the smaller population. If we look at the creation of UTs with the prism of 1956, then it satisfies the situation there, because at that time those UTs who were created to be the UTs, they had the low resource base, and also they have the low resource base, and also they had the smaller population. For example, when you have the low resource base, what would be your dependence? Even though you are state, you will always be dependent on center. So isn't it good to make isn't it preferable that to make it a UT rather than making it a state and then being dependent on being financially that much dependent on center? So it was preferable. If you have low resource base, then definitely you should be a UT. And second, the smaller population. For these places, for example, Andaman and Nicobar, they had very small population. They had very minimal population. So for that, let them have a democracy, but in a different way. Let them have a democracy at the advisory capacity. They will advise the lieutenant governor. They will advise them what to do, how they should govern them. But we cannot, for this smaller population, and also they don't have the resource base, we cannot create a well established system there which will even consume their resources, and eventually it will lead much pressure on the resources there, on the people there. So these were the 2 reasons which were discussed and decided. These were the 2 reasons on which it was decided whether the state will be UT, or whether any area it would be considered UT or not. So on this basis, but as I told you, if we look at it through the prism of 1950s, it was correct, but still right now it is not that relevant. For example, let's have a look at other places, other areas which had been given the statehood. For example, let's have a look at the Sikkim. What is the population of Sikkim? It is only when it became the state of India. When it became the state of India, what was its population that time? It was only 2.5 lakh 2.5 lakh population. Then we have the example of Mizoram. What is its population? It is only 6 lakh. Then we have Arunachal Pradesh. What is its population? It is only 8 lakh. And when we will compare it with the Delhi, with the population of Delhi, it is considered that the population of Delhi is more than the 130 countries in the world. More than 100, in 130 countries, what is their population? Not added together but separately, Delhi's population exceeds those 130 countries. What is the population of those 130 countries? The Delhi's population is more than 130 countries population. So this is the understanding. So for this reason, why not we give the Delhi, for this reason, if the population is the base for the UTs, then why not we give the Delhi the statehood? Then the second reason which was highlighted in this is the low resource base. Yes, we agree that few places, few UTs, they have the low resource base, but what about whole Northeast? They have the low resource base. The terrain is different, the geography is different. You cannot build roads that much. You cannot establish industries on such terrains. So definitely this cannot be the reason. These cannot be the reasons. These cannot be the reasons relevant in the present time. So what is the solution? Now let's move to the solution. Here we established what was the reason for the creation of the UTs. For the creation of the UTs, there are 2 reasons. which were highlighted in the State Reorganization Act of 1956. What were those two reasons? First, low resource base, second, smaller population. But when we will analyze these two reasons, we see that there are many states who have lesser population, but still they are enjoying the statehood. And we see there are many states who don't have the economic base, but still they are the states. So in our country, in our country where we believe in absolute, we believe in equality, we believe in democracy, how in such country which believes in democracy, which is the world's biggest democracy, in such country how we can discriminate people on this basis? If we look at the preamble, what does the preamble talk about? Political equality, political justice is there, political justice is there, justice in political domain. So how can this political justice be satisfied by the people when they have the rights, when the rights are equally shared by them, when they have the right to elect somebody who will work for, who will make laws for them, who will who will listen to them? So if this is not available to people in the UTs, then definitely there is discrimination. Then definitely the people of UTs, they are being discriminated as compared to the people of states. So in this democracy, in the present democracy, the India's democracy, the world's biggest democracy, it should not happen. So that is why there is a question. There can be the question, is the UTs relevant in the present time? So what can be the solution to this? Let's see. Let's take the example of Goa, which earlier was the UT. So how did Goa attain the statehood? Let's take the example of that. How did it attain the statehood? How did it acquire the statehood? For Goa, what we did a referendum, a kind of referendum, where the people were asked to either be a full-fledged Goa, to be a full-fledged state, or to merge with the nearby state, like they have the Maharashtra nearby. And the third one was to remain the UT. And majority of the population in Goa, they chose for the full-fledged state. So in this way, Goa became the state. Then we have the example of Manipur here. We have the example of Manipur. How did Manipur become the state? Through the violence, because there were insurgencies and they snatched it from they in a way forced the center to make the Manipur as the state. They snatched this statehood for themselves. So it was attained by the violence. So should we wait for every UT? And the question which everyone would ask, should we wait for these UTs to go through the violence and then get this statehood? No, it can't be the solution. Now what can be the solution for this? For it, what can be the solution? As we can see here, the solution is very much clear by the example of Goa. What are the solutions? First, do the referendum in those particular states. Either if they will choose for the statehood, give them the statehood, because our criteria, even though it will have the economic cost, but what is our principle? The principle of our democracy is that we believe in absolute democracy. We believe in that everyone is equal. So to have this, to show it to the world that there is no discrimination in any way in our country, to show this, we can do this. And still, there are, as we discussed, that there are many states, even though they did not have the economic capabilities of their own, but still they are enjoying the statehood. So why not let them decide for themselves whether they want to have the statehood, or second, they want to merge with the nearby state, and in which state they will merge with those states with which they share the cultural and linguistic. They are culturally and linguistically very close to them. They can be merged with them. For the solution of the UTs, this could be the answer. And for the third, if there is necessity for any particular UT to be the UT, for example Andaman and Nicobar Island, that can be created, that can be stayed as the UT for the exceptional purposes. So this should be the solution, that either there should be the full statehood, or they should be merged with the other states, so that they enjoy this right which is enjoyed by whole of the country, by all the states in the country. So now let's see what can be the solution for Delhi, because Delhi is the capital. We discussed that, like in USA, they have the Washington, which is the capital there, and they have the central control there. But if we'll really discuss the Washington and we discuss Delhi, there is lot of difference between the two. Why? Even though there are federal feature, federal institutes are there, there is central business is going on there, there are embassies are there, there is assembly is there, legislative assembly is there, there is Raj Bhavan is there, everything is there. But at the same time, the difference is that there are huge number of civilian population. There is huge number of civilian population. So what can we do with respect to Delhi? What can be the solution for the Delhi? The solution can be, this UT having a legislative assembly is not a solution. You can be a UT without a legislative assembly, then you cannot question anybody. You can question anyone. At least you can question the center for whatever is happening in the state. For example, let's take the example of Delhi. If anything happens in the Delhi, for example, pollution in Yamuna, if there is pollution, if there is environmental pollution, what Delhi does? Delhi government, they say, why do you ask such questions to me? Go ask the center. And when you ask the center, they blame, go ask the Delhi government. So there is always, there is no accountability to the actions. But if this legislative assembly is abolished, then we can directly approach to the center, sir, what is happening there? Bring us with some good laws so that we can have the good environment, we can enjoy our fundamental right. We can ask such questions to the Delhi, to the center directly, to the president directly. And the another solution which the experts highlight here, that if we look at the Delhi, NCT Delhi, it is very big. The population is very huge. And if we look at the federal structures in the Delhi, the central institutes in the Delhi, they are confined in an area called the New Delhi. They are confined in the New Delhi. So what the solution is? The solution is that bifurcate the Delhi. Bifurcate it into the New Delhi and the Old Delhi. It can be the name or whatever you would want to name them as. This New Delhi, it should be made the UT, and this Old Delhi, it should be given the statehood. So this can be the solution. And for this New Delhi, there can, in this New Delhi, there should it should be UT without legislative assembly. So this can also be the solution. So this is with respect to the UTs, how it is relevant in the present time. The reasons highlighted by the State Reorganization Act, it highlighted that the first, less population, and second, no resources. But still, if we look it through the prism of present time, it does not stand, and the present values are different. The democracy is cherished by the world. The democratic values are cherished by the world. And what does the preamble talk about? Preamble talks about that there should be the political justice in the political sphere. So are they enjoying the justice in the political sphere? Are they able to, they are not even able to make their own government there, in the 5 UTs. So definitely it is outdated term right now, and we should go for the new reorganization. New state reorganization committee should be formed, and they should be discussing about this, and it can be the solution for our exam. So I hope you had understood this question, which was very much important for you to understand. Now there is another UT which was created recently, which is the UT of Jammu and Kashmir. So let's try to put some light on Jammu and Kashmir, even though Jammu and Kashmir Article 370 is not that relevant now. It can't, they are not going to ask you a question, but maybe in the mains they may ask you a question about it in any way. So for that, you need to have the brief information about Article 370 and with respect to Jammu and Kashmir. So let's try to discuss J&K now. Jammu and Kashmir Article 370 and Article 35A. What are these articles? Let's try to discuss that. We will try to discuss it in a very short time period, so that we will not waste much time on this discussion, because it is not that important for your preparation. But still, you need to have the idea of this. Maybe any question would be asked in the exam. So let's have a look at. Let's go back during the times of independence. Before independence, few years back, before independence, what was the status of India? What was the status of the British India? There were, as we discussed, there were few states which were the bigger states directly in control of the British. There were few states which were the princely states. So we can divide it into this. There were princely states and there was the British territory. So in 1947, before independence, there were approximately 562 princely states in India. How many? 562 princely states were in India at that time. And when India was bifurcated, or we can say when we got independence, at that time, the independence of India was decided. Independent bifurcation of Pakistan was decided. So what will happen to these princely states? For them, they had three options. What were the three options? The first option was either to be independent. Second option was join India. Third option was join Pakistan. So these were the options left with them. It was, as it is believed, that it was Sardar Patel's hard work. Because of Sardar Patel, majority of these princely states, what they did, they joined with India. Because of Sardar Patel, majority of these princely states, they joined with India. But there were three princely states on which the decision was yet to be taken. What were those three princely states? It was Hyderabad, it was Baroda, and it was Jammu and Kashmir. On these three princely states, the decision was yet to be taken. So the situation was different. In Hyderabad, it was under the Nizams, the Muslim ruler. In Baroda, here also the Muslim ruler, but the population was majorly Hindus. Here J&K, it was the opposite of Baroda, and it was Muslim population, but leader was the non-Muslim, or we can say Hindu. So this was the situation there, and this was the thing. These were the important, three princely states on which the discussion was yet to be, on which the decision was yet to be decided. So what did Hyderabad chose? Hyderabad chose that we will remain independent. If you look at map of India and seeing Hyderabad independent, or it had sided with Pakistan, it would have been big problem for us. So this was an issue. And Baroda, they also chose to be, the Muslim leader was there, they also chose to be independent. And for Jammu and Kashmir, they also chose to be independent. It was their decision. But the question here was, the problem here was, as it is highlighted by the Raj Mohan Gandhi, that Sardar Patel, it is believed that Sardar Patel was ready to negotiate with Pakistan or Jammu and Kashmir on these two princely states, that we will get these two princely states, you get Jammu and Kashmir. But because of Pandit Nehru, this negotiation could not be completed. And eventually, in Hyderabad, because of the army action, the Nizam surrendered and the Hyderabad became the part of India. And in Baroda, there was a referendum was carried out and people voted for being the part of India, and Jammu and Kashmir was settled there, and it was the independent, in a way, it was independent state. In 1947, Jammu and Kashmir was independent state. But, you should remember one thing. Jammu and Kashmir was under the princely rule when in 1941 there was Quit India movement. At the same time in Jammu and Kashmir there was also Quit movements continuing, but it was Quit Kashmir movement for the king of the Kashmir, or for the prince of the Kashmir, that he should quit Kashmir. So this was going on there, this tussle was going on there. So eventually when Jammu and Kashmir, it was given it chose to be independent. The prince was there who was ruling it. At the same time, Pakistan, they did not like this decision. So what they did, they saw that how India acquired the Hyderabad, so they tried to do the same, but in a different way. The tribals in Pakistan, we call in Kashmiri Kabali, the tribals in Pakistan, what they did, they entered Kashmir and they started to take the territories one by one, and they started to grab one by one territories, and it is believed that they were just few I guess 50 to 100 kilometers away from Srinagar. So the prince of the prince of Kashmir, what he did, he 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 fled from the Kashmir. He went to Jammu, and in Jammu he met Mr. Lord Mountbatten and told him to help us. But the Lord Mountbatten told him, how can we help you? You are the independent state and we cannot interfere in your personal matters. So he told, sir, please help us because Pakistan is about to take my territories. These Kabalis are about to take my territories. So please help us in this regard. Then eventually the Mountbatten, he told him, if you want us to help you, then you should do one thing. Sign the instrument of accession. Sign the instrument of accession. For these princely states, they have to sign two documents to be the part of India. First, they will sign the instrument of accession, then they will sign the merger agreement, so that eventually this will be the part of India and the office of this will end. So they told them sign the instrument of agreement, and eventually he signed the instrument of agreement. And next day, the Indian Army was on the Srinagar airport, and eventually the Indian Army tried its best to reclaim the territories back. But still, there are few territories of Kashmir which is under the Pakistan's illegal occupation. So this is the story till now. Now what happens? It was the time when the constitution was being created by the Constituent Assembly in Delhi. The constitution was being created, and at this time, once the prince fled, it was the most popular leader in Jammu and Kashmir, and his name is Sheikh Abdullah, the grandfather of the present CM of Jammu and Kashmir, Umar Abdullah. Sheikh Abdullah, he was the most popular he was the most popular leader of the Kashmir at that time. So what he did, he met with Nehru, and finally Nehru, he came to Kashmir, and in Srinagar there was huge meeting. People attended them, and Nehru proclaimed few important points there. What were those points? They are worth remembering. First, Nehru told that we want you to be the part of India. It is we have love for you, because Nehru eventually he was Kashmiri. We want Kashmir to be the part of India, but you will decide over it. There will be a referendum, and you will decide whether you would be part of India or Pakistan. But we want you to be the part of India. But at the same time, it was 26 October 1947. What Nehru did, not before 26 October 1947. At the same time, I guess I am mixing the dates. Sorry. When first I missed as important point here. When these Kabalis, when they captured the land of India, so Nehru, what he did, PM Nehru, he went to the UN, and he went to UN and approached UN that India wants its land back from the Pakistan. But at that time, the situation had already changed. UN, it was very much under the control of US, and we know that the partnership between US and Pakistan had already started. So this war was going on between India and Pakistan, and eventually the ceasefire was decided, was proclaimed, and the line of control came into existence. And the UN said that there would be the referendum. You should go for the referendum. And by the help of Pakistan, what was the referendum? Either to stay with Pak or to stay with India. Kashmiri people will go for this referendum. They will either decide to stay with Pakistan, or they will decide to stay with India. Eventually Nehru realized that it was not the good move for him to go to UN, and what he did, he met Sheikh Abdullah, and he came to Kashmir, and there was a rally where he said that, where he proclaimed that few important points would happen, where he proclaimed that there would be few important points would be there. We will create the, you will be the persons, you will be who will decide to which place you want to join. If you want to join the Pakistan, you will decide that. If you want to join India, you will decide that. And for that, and also the constituent assembly, we will create the constituent assembly for was promised for J&K. At the same time, we will create the Constituent Assembly, which was promised for J&K, where they will make their own laws. Jammu and Kashmir will make their own laws. Whatever will stand with the Jammu and Kashmir, they will decide it. Till the Constituent Assembly is created, we will create an act. What is that act? That act is Article 370. Till the Jammu and Kashmir is created, we will create this act, that is Article 370. And this Article 370, till the Constituent Assembly is created, this Article 370 will will be there in our Indian Constitution, and it will decide the Kashmir's relation, Jammu and Kashmir's relation with India. So what does this Article 370 says? Article 370 says, Article 1, which is India, the Bharat, and this Article 370 says, this Article 1 and Article 370, except in the full Indian Constitution, only Article 1 and Article 370 will apply to Kashmir. So Kashmir being the Indian territory, and then this only Article 1 will apply to them, and Article 370 will apply to Jammu and Kashmir. Then we know that Parliament, we know that how there is distribution of powers between UT and Parliament and the states, that Parliament can make laws on the union list. Under Article 370, there was this term also, that in the union list there are 97 items. Out of these 97 items, only 3 items are there on which the Parliament can make law, Indian Parliament can make law. Rest are kept for the state, for the Kashmir, Jammu and Kashmir. They will make laws on the rest of the items. So only 3 items in the union list, and only 2 articles of the full Indian Constitution will apply to Jammu and Kashmir under Article 370. So what were these 3 subjects which would apply to the Jammu and Kashmir? These 3 subjects which will be under the control of the Parliament. It would be defense, it would be external affairs and the foreign policy, and it would be the communication. These 3 will be with the center. Parliament will decide that. Rest, it will be decided by the it will be decided by whom? It will be decided by the J&K Assembly. So this was promised by Article 370. And then further, Article 370 does not end here. Then further, Article 370 says that if the president have to issue, if you want, for example, suppose tomorrow the Kashmir wants that other provisions of Indian Constitution should also apply to the Kashmiri people, to the Jammu and Kashmir. How it can apply? Article 370 says that the Constituent Assembly of Jammu and Kashmir, they will approach the president, ask the president, then under Article 370, then the president will have to issue an order under Article 370 that this particular subject or this particular article of the Constitution will apply to Jammu and Kashmir, and with in this there are also the exceptions are also given there. So let me repeat it so that you will understand. Here we are discussing Article 370. Under Article 370, we discussed that Article 1 and Article 370 applies to Jammu and Kashmir. Second, Parliament of India has powers with respect to only 3 items under the union list with respect to Jammu and Kashmir. Rest is with the Constituent Assembly of Jammu and Kashmir. Then the third, we discussed that what were those items? It is defense, it is external affairs and foreign policy, and it is communication. Then we discussed that suppose tomorrow, at that time we are discussing it, we are raising the question, suppose tomorrow Jammu and Kashmir wants, the Jammu and Kashmir Assembly or the Constituent Assembly of Jammu and Kashmir, they want that fundamental rights should be part of, should also apply to the Jammu and Kashmir. So in this case, how it can be, how fundamental rights would apply? For that, they will have to, they will have to request the president. The president will make an order. President will make an order, issue an order, under Article 370, that particular article or particular, particular law will also apply to Jammu and Kashmir. But in this, it will not apply fully. There may be limitations on that. There may be, exceptions with respect to that fundamental rights. For example, I will give you the example with Jammu and Kashmir. When in 1954, when there was The Sheikh Abdullah was eventually arrested because he did not wanted fully that Indian constitution should apply to the Jammu and Kashmir. He was not well good with the negotiations. After that, the Bakshi, Mr. Bakshi Muhammad, he became the prime minister. Bakshi Ghulam Muhammad, he became the prime minister, and he agreed with the conditions of Indian government, with the exception. What was the exception? That, for example, he agreed that fundamental rights should apply to the Jammu and Kashmir, but there is an exception that the non-natives of Kashmir, Jammu and Kashmir, that non-Kashmiris, they cannot buy land in Jammu and Kashmir, which was way against the equality, which was very much against the Article 14, but still it was agreed, because this Article 70, it has the clause that it can bring up these fundamental rights, it can bring up the provisions of Indian Constitution into Kashmir, but with it may be fully or with exceptions. So it was very much, it is what Article 370 says. Then how can Article 370 cease to exist? Now the question, the another remaining question which you should ask me, that then what does the Article 370 say about it cease to exist? About it, it should be on the recommendation of Constituent Assembly of Jammu and Kashmir. They would request the President, and President will seize the Article 370, and Article 370 will cease to be exist. So this is what Article 370 is. These were the provision, few important provisions under Article 370. It has, Article 370 has the self-destruction clause in it, that how I can end when the Constituent Assembly in Jammu and Kashmir, they will request the President, please end this article, then this article will cease to exist. And then we saw that, when this Article 70 was formed in Jammu and in Indian Constitution, there was huge hue and cry over it. There were discussions. Dr. Ambedkar, he was totally against it, that he did not want it. And many leaders in Constituent Assembly, they said that if we have the one nation, why should we have two PMs here? Why should we have two separate constitutions for that? So there was huge discussion over it. There was a huge hue and cry over it, and eventually the Prime Minister Nehru said that, and other leaders said that, Article 370, it is not a barrier. It will be a tunnel, and it will be a tunnel in which the Indian Constitution, by provision will enter into Jammu and Kashmir. So, and eventually it happened. So it started to happen in 1954, when through the President's Order of 1954, when the President's Order of 1954 was issued, when earlier before and the Sheikh Abdullah, he was arrested for 23 years. Sheikh Abdullah was arrested, and the President's Order of 1954 was issued. Under this order, now the President, various Indian provisions started to enter into the Kashmir. For example, fundamental rights, CAG, Supreme Court, Election Commission, and all that, they started to enter into the Kashmir. So it was celebrated by the people in India, but at the same time there was a clause which was added, which is clause Article 335A. It was added. Clause A was added under Article 335, which said that about the state subjects, that those who are not the state, the Jammu and Kashmir will decide who are the real people of Jammu and Kashmir, and with respect to the trade in Jammu and Kashmir, who can buy the property, who can sell the property, the outsider cannot buy the property. It was very much established under Article 35A. So after that, the things started to change, time by time, they started to change one by one. Bank nationalization happened, and all that stuff started to happen. And eventually in August 5, 2019, the President's Order, by the President's Order 272, President's Order 272, the article under this President's Order 272, Article 370, under Article 370, what did it said? That all the provisions of Indian Constitution are applied to the Jammu and Kashmir. Prior to this, out of 97 provisions, only 94 were applicable to Jammu and Kashmir. Now all the provisions of the Indian Constitution are applied to Jammu and Kashmir. It was decided, and eventually, this special status of Jammu and Kashmir was annulled, or we can say Article 370 ceased to, Article 370 was in a way, was reduced to only few clauses. So how it was to be done? It was how this Article 370 should cease to exist. What was the criteria for that, which we discussed, that it is the Constituent Assembly of the Kashmir will ask for it. The Constituent Assembly of Jammu and Kashmir, they will ask for this, that Article 370 should cease to exist. Constituent Assembly of J&K, they will request whom? The president, and then president will give the order that from today Article 370 ceases to exist. So it was the self-destruction clause. But what happened? Before this president's, before August 5, 2019, what happened, that there was no, the Kashmir was under the president's rule. When Kashmir was under the president's rule, we understood that the legislative assembly, it is the laws are formed by the parliament, and the executive comes under the control of the president. So what president did, the legislative assembly, the parliament, they said the they requested the president, the parliament, which was acting as the legislative assembly for Jammu and Kashmir also. So what they did, they asked the president, please abolish Article 370. It should cease to exist, and eventually the president gave the order. And then matter went to the court, and they said that was it legal or not. Eventually the Supreme Court in 2023 judgment said that it was very much legal, but there were few terms which were used, they were unconstitutional. For example, they highlighted that the Constituent Assembly is equal to the Legislative Assembly. So Supreme Court said that this is not, this is unconstitutional. Constitutional Assembly, it has the sovereignty. Legislative Assembly does not have the sovereignty, and it cannot be, Constituent Assembly cannot be the Legislative Assembly. And the second term, why it upheld the decision of the center, it said that if we look at the Article 370, it says that if you want to change the status of Article 370, you need to take the permission of the Constituent Assembly. But Constituent Assembly was not there, so president can take this decision on its own. So on this basis, it was made that that Jammu and Kashmir will Article 370 will cease to exist. Then through other order, it became the Union Territory. So this is the whole story about Article 370 in a nutshell. I tried to skip much information in it because it is not relevant for your preparation now. That's why I reduced it to the highest levels. So with respect to this, I hope for the interpretation of the Constituent Assembly, the article which was used is Article 367. It was used for the interpretation of the Constituent Assembly, and the Supreme Court said that it is unconstitutional, that you cannot interpret Constituent Assembly into the Legislative Assembly. So this case was heard by the Supreme Court, and the name of the case is a reference to Article 370. So this case was heard by the Supreme Court, and eventually this Article 370 was it ceased to exist. It is still there. If tomorrow government will decide that it will also come into power, they can decide it in whatever way they would want to. But right now, it does not exist. It is there, but it does not exist. So this is the story of Article 370. I hope you had understood it. Little boring, but very important. Now let's move to the another topic of today's discussion, which is center-state relations. Let me rub it first, so that we will have a clear board here, and we will start our discussion on center-state relations. Center-state relation. Center-state relation. If we look at this, in our country we have the federal structure. In normal conditions we have the federal structure. But we discussed that how in emergencies, the center is the sole power in a way to make the laws. How in a national emergency is there. How if there is president's rule, if there is financial emergency, then these powers will alter a little bit. So with respect to this, to understand the center-state relationship, we have to understand the distribution of powers, how the powers are distributed. Distribution of powers. We have to understand this distribution of powers in three ways: in the legislature, in the legislative way, in the administrative way, and then in the financial way, how they are distributed. With respect to the financial way, we will discuss that in Indian economy, because we have to discuss it. We have to discuss GST, we will discuss that. But here we will discuss the legislative and administrative manner, how it is distributed, how it is defined in the Indian Constitution. For that, we have to look at the articles between Article 245 to Article 255. These are for the center-state relation. So let's see what kind of what is the relation. Suppose there are we have the seventh schedule, in which we have the state, we have the union list, we have the state list, and we have the concurrent list. Tomorrow, suppose any state will make any law. Any state will make any law. Suppose state will make any law. Can this law extend to the other states? For example, Uttarakhand, they came up with the uniform civil code. Can this uniform civil code extend to the other territories too? The answer to it is no. It will be confined. So what does it say? It says that state can make laws for the state, for the territories in the state, in whatever territory state has. In that territory, the center can make laws. The state can make laws, except those territories in the Schedule 5 and Schedule 6. We had discussed that already. Here we are talking in general. Now let's suppose center will make law. Will that law be implemented in any part of India? 100% correct. This law can be implemented in any part of India, whether states would like that or not. We have the process for that. If the federal structure is being changed, then definitely it will be applied in any part of the country. Then what about the extraterritorial? Can state make laws on extraterritorial matters? No, state cannot make. Can center make? 100% center can make. So let's define it. So you can ask me a question, sir, define this extraterritorial. Are we going to make the laws on the Pakistani soil? Are we going to interfere with that? No, it is not like that. I will explain you. Suppose, what is the biggest issue with respect to the business right now, or with the biggest issue with respect to earning money, or we can say biggest issue, if we look, paying of taxes. You earn money, but you have to pay the taxes. It is very much understood. But what few people do, for example, they are in real estate, they are selling any flat or any house, or suppose they are selling it for the 10 crore, but the market price is only 5 crore. Nobody will sell only 5 crore. So they are selling it to party. Here is party A and here is party B. They are selling it to party B. What they will tell party B, that what do? You send 5 crore into my bank account, and for the rest 5 crore, give me in the cash. So that only these 5 crore will be accounted, and the government will collect tax from these 5 crore, and this 5 crore, it will be my money. So it would be the unaccounted money, or we can say it will become the black money. So this is a discussion. Now where will they keep this money? If they will keep this money at the home, there would be raids from the police, anything can happen. So what they will do, they will think some of their friend, it will tell them, why not you send this money to the foreign countries, like we have Swiss banks there. Just make create an account there and put this money in this Swiss bank, so that they will not share the information and your money will be safe. This is the normal trend. When 2014 elections were there, and one of the major claim of the BJP government was that we are going to collect whole black money, through which they brought in demonetization. And it was claimed by PM Narendra Modi that if we are able to collect all the black money from the international markets, which the Indian nationals have, you know how much money we will have. This was the claim from the Narendra Modi, that once we will collect all the money, you know how much money we will have, that even after collecting this whole money, if we will give 15 lakhs to every person, we can give, after collecting this whole money, we can give 50 lakhs to every person in our country. So because of this, you know, it is always alleged against the BJP that they had claimed that you vote for us, we will give you 15 lakhs. Actually, this was not the real story. What they said, that if we are able to collect all this money, if we will distribute it between the people, distribute it in with the people, it will be 15 lakhs. Will get, every citizen will get 15 lakh. It was the real story. So this is what it is. Now, what can be the solution for that? They are spending this. They are sending this money to the Swiss banks. Now, the one of the solution is that why not we nationalize the why not we nationalize the bank accounts of the Indians which are outside the Indian territory. Why not we nationalize these bank accounts of the Indians, and once we will know the amount, we can transfer it to the Indian accounts, and eventually we can curb this black money. So this is one of the reason, one of the solution. So how can we do this? Can parliament, can state make law on it? No, it is the parliament who has the authority to make law on it, because they have to make law outside the territory on something which is outside the territory of India. So it is the parliament. So this is the kind of relation which we have, which the states have with the center. It is the center which can make laws on that. Then we have, after this, you know, basically when we are discussing the center state relation, here you have to understand few important points. This topic can be very much important for your prelims as well as mains. So here what we are trying to collect, trying to collect the information which is relevant for your prelims preparation. Then we will try to collect the information which would be relevant for your mains preparation. So in today's class, we will collect the information which is relevant for your prelims preparation. So this is one way. Then we have Article 246. What does Article 246 say? It says the distribution of items under, it gives the space for the 7th schedule, and it says the distribution of items between the union list, state list, and the concurrent list. What does Article 246 say? Article 246, it gives the space for union list, the state list, and the concurrent list. In union list, we have, for example, defense, we have there, we have banking there, we have, you know, we have foreign relations, we have currency, we have communication, we have atomic energy, various items. There are 97 items in the union list. In the state list, we have agriculture, we have public health, we have public order, we have police. In the concurrent list, we have education and various other items. So how it will be done? If the center will have to make any law, it will make on the center list, on these. If the state will make any law, it will make on this. And now what about the concurrent list? Both the center and state can make laws, but here is a question, that suppose center has made any law, then the state will make the law which is in contradiction to the central law. Then what will happen to this? If it will be passed by the parliament, it is not recommended for the president, then it will cease to exist. If this bill is recommended for the president and president approves, then it will remain there. Otherwise, there is a doctrine which is followed, which is doctrine of pith and substance. So let's try to understand what is this doctrine of pith of substance. We'll understand it through the example of Rajasthan. You know, Rajasthan, what they did, they imposed a ban. Imposed ban on what? Imposed ban on loudspeakers. That loudspeakers will not be in use from every day from 10 p.m. to 6 a.m. And the purpose why? So that it will help in improving the public health, for the better of the public health. For the public health purposes, they imposed ban on the loudspeakers. But loudspeaker is a source of communication, and communication comes under what? It comes under the union list. Now there was a confusion. Can the state make law on any item which is in the union list? So this discussion was there, and eventually state Rajasthan is saying that we are making law on public health. The center is saying that they are making law on, they are curbing the communication. Eventually matter went to the court, and this doctrine of fifth and substance was established. And under this doctrine, it will be seen what is the real intention of the state. If they are making any law, or if the center is making any law, what is the real intention? If real intention is that which is in their list, then they can make. If the real intention is not that, then this law will not be valid. So this doctrine of public fifth and substance was established. Similarly, we have the example of the farmers farm laws, which were brought in 2023. 2020, the farm laws which were brought in 2023 farm laws. Let's put some light on those three farm laws, even though they are not important for your preparation, but maybe in the exams you would have to write the answer. You can highlight the example of those farm laws. Farm laws, if we will see agriculture, it is the part of what? Agriculture, part of state list. So how can center bring up the farm laws? So let us discuss what were these three farm laws. Three farm laws were, first law was Farmers Produce Trade and Commerce Promotion and Facilitation Act 2020. Then the Farmers Empowerment and Protection Agreement on Price Assurance and Farm Services Act of 2020, and the Essential Commodities Amendment Act of 2020. So what were these? Let's try to understand first. For example, if you are a farmer, you have land and you are growing some crops here. You will sow the crops and you will harvest it. Now you want to sell it. Where you will sell it? You will set it in APPSC Mandi. In the Mandi you will sell it. And how you will sell it? There would be some person who will act as a middleman. You will approach him and he will sell it to the another person. This will be sold to another person, and this profit will be shared. He will get some commission out of it. So this is the practice before farm laws. What did the farm laws said? Farm laws said, because of this practice, these farmers, what they are doing, they are losing what? They are losing huge amount of profit, because they are sharing their profit with the middleman. So what they will do, what was the purpose? What purpose was, why not we double the farmers income? The purpose was, why not we double the farmers income? So the purpose was to double the farmers income. And now the situation was, suppose in your state there are few mandis where you can sell it. In the states you can sell anywhere, but what did the government said? Why are you selling in this mandi? Because there is in another state there is another mandi, you can sell there. You said, sir, I can sell there, but I have to pay the taxes. Then the government said, let's end these taxes, don't pay these taxes, go and sell wherever you want to sell. Or you can do what? You can directly contact MNCs and you can sell your produce to them, and they will give you the better money, they will give you the better results, they will give you the better profit. When you will look it through this, it seemed more genuine. Why did you may question, why did farmers they protested against it? The reason for that was very much clear. The aim, what was the aim of the government? The aim was to double the farmers income. But what do farmers think? What was the aim of the government? Farmers think the aim of the government was to end the business of these middlemen. When there would be no business, no middleman, then farmers will directly sell their produce to these MNCs. When these MNCs will come in picture, initially they will give them the good profit. But once this monopoly is enjoyed by these MNCs, they know that they cannot sell anywhere. What they will do? They will reduce the prices, and eventually it will impact the income of the farmers. So farmers acted very smart and they did not agree to it. Then the second what was the second law? This is what the first law was, the Farmers Law, which is Farmers Produce Trade and Commerce Promotion and Facilitation Act of 2020. Then we have the Farmers Empowerment and Protection Agreement on Price Assurance and Farm Services Act 2020. So let's see, what does it say? What does the second law say? So second law dealt with what? It dealt with the national framework for contract farming. What? National framework for contract farming. So what will they do under this? Farmers and companies will come into the agreement, and companies will tell them which crop they should decide and which crop they should sow, and the companies will in advance tell you what would be the price of the crop when they will sell it, what would be the price of the crop, and companies will give them the crops. So this was the agreement between the farmer and the company, and eventually the farmer was forced to sell their produce to the companies only. They have to sell their produce to the companies only. And this also, the farmers did not like it, because it eventually they highlighted the example of PepsiCo with the farmers in Maharashtra, I guess. They had the agreement, and eventually when the farmers brought their produce, the company said that these are not good for their business, so they did not buy their produce. So eventually it impacted the farmers income. And then the third one was the Essential Commodities Act, which was amended. Under Essential Commodities Act, earlier what was, for example, you are selling the potatoes, you are selling onions, you are selling tomatoes, eventually they are all round. Now if you are selling these, you know what will the companies do? What will the huge giants do? They will buy this produce in the huge quantity, and they will hoard it, and they will stock it, and they will in a way impact the market price of it. It will impose in a way kind of, it will impose a kind of it will impose a kind of, what is the term, economic term, I'm forgetting it, inflation. It will impose a kind of inflation in the market, and once the prices will raise, when they will cut the demand, they are not letting this come into the existence, they are not letting their produce into the market. Once they are not letting the produce to enter into the market, the prices will increase, and eventually when they will artificially alter the market prices, and then they will release their produce and they will get the benefit. Earlier tomatoes was part of it, onion was part of it, and potatoes were part of it. So what did this amendment did? Amendment did that it eliminated, it removed tomatoes, potatoes and onions from the Essential Commodities Act. So they are not any more essential commodities. So what will it lead to? It will lead to the private sector to come in. They will buy it on any basis. They will buy it bulkily, and they can manipulate the market. So this was not liked by the government and by the farmers. So they revolted against it, and eventually the government was forced to drop this idea, drop these acts. And what did the government said about the Essential Commodities Act? They said that we need cold storage in our country. We have huge amount of food or crops, but they are they are prone to damage. They are prone to damage. They are perishable goods, and if we have the cold storage for them, we can increase the lifetime for those products. But eventually the farmers did not like it. Now the question is, the agriculture, which is the part of the state list, can the center make the laws on it? Can the center make laws on it? The question to it is the yes. Why? Because there is a concurrent list, and in concurrent list there is list 33, entry 33, which says that in the trade and commerce, for the interest of the for the public interest, parliament can also create the laws in which they can alter these things. So even though in trade and commerce, with respect to trade and commerce, for the public interest, parliament can do it. Initially, it was brought only for it was there only for 5 years. When the constitution came in, it was there only for the 5 years. This entry 33, it was only for the 5 years. But what happened? At that time we were very poor. We were very much dependent on the aid of other countries. And eventually, by the third Constitutional Amendment Act, by the third Constitutional Amendment Act in 1954, this was extended indefinitely. This was public interest it was extended indefinitely. So yes, the center can make laws if it is for the public interest. Now this is about the relation, yeah, about through under article 246, how they make laws, where does the pith and substance come in, the doctrine of pith and substance come in, and where center can intervene if there is the bigger public interest. Now there we have, now we have article 249. Let's see what does the article 249 say. Suppose tomorrow, central government, they would want to make a bring in any law. For example, they would want to bring in the death tax, that after the death of the owner, the this inheritance tax. Suppose they would want to bring in this inheritance tax, that the property should be shared. Agricultural land, it should be 30% will go to the government and 70% will go to the inheritant, maybe the son and the daughter. Suppose they would want to bring in such law, and for that they would want it to be implemented by the states. How they can do it? They can do it by article 240 249. They have majority in the Rajya Sabha, suppose, and through article 249 parliament may make law. If Rajya Sabha will have to pass resolution by the 2/3 majority present and voting, if the Rajya Sabha passes the resolution by the 2/3 majority present and voting, at 2/3 majority at present and voting, if the parliament passes the law in the national interest, that it is important, then parliament can make laws on the state list for the states too. And the validity of these laws would be 1 year, and after every 1 year, it would be it would be approved. They need the approval of Rajya Sabha every time. So this is article 249. What does it say? Then we have article 350. It is during national emergency. We had discussed that under national emergency, that how parliament enjoys the concurrent power of the legislature, that the union list, the state list becomes the concurrent list, and parliament may make laws with respect to the state list too, and the validity of those laws is 6 months after the revocation of the national emergency. Then we have article 352. When states, under article 352, how does it apply? When, for example, states would request, they would want center to make any law with respect to any item. So what states will do? States will make a request. When 2 or more states pass a resolution requesting parliament, then the parliament may make the law on those states. 2 or more states will make the request. 2 or more states will make request to the center, and then the parliament will make the law, and this law will be applied in these 2 states, or how many states requests in these states only. What if tomorrow other state will want to apply this law? Then they can adopt it. They don't want to move to the ask the permission, they can adopt it. Then we have article 253. What does article 253 say? For example, India has signed any international treaty. For example, India has signed the UN Convention Against Corruption, and we had ratified it in 2008. And under this convention, that every country who has signed it, that they will have to pass the domestic law with respect to the corruption. And we brought up the Lokpal. We brought up the Lokpal and Lokpal Act and at the center, and Lokyuktas at the state. So was it constitutional? Yes, because if we are under the international agreement, then the parliament may make laws for both center and the state. So this is what article 253 says. And also during the president's rule, the state legislature comes directly under the Lok Sabha or the center, and the state executive becomes the president, and then they can make laws. And after the president's rule is over, it will continue to be there until it is revoked. Then we have central control over the state legislature. That is also one of the drawback of it, central control over state legislature. For example, if there is any bill which is controversial, that bill will be reserved for the president. and then president will approve it, approve it or not. That is also one of the controversy of our federalism. Then we have the financial emergency. The state will decide for the center will decide for the state what will happen to the money. What would happen to the salaries and all that with respect to the posts in the state. So with this, I hope you had understood today's discussion. If there is any confusion, please do write in the comments. We are here to help you. This initiative is for you guys. Please do subscribe it, do share it with your friends, and do hit the like button. And please do read our notes. Yet they are not ready, but once we will complete our syllabus for Indian polity, they would be ready. And once you will read those notes, it would become much clear to you. It would be very much easy for you to crack the prelims as well as mains, and I hopefully interview too. So with this, I would like to thank you guys. Thank you for staying with me. Thank you very much, and have a nice day.